Welcome to Seeking Disability, the show that helps you in seeking disability. I'm Tom Duncan of Duncan Disability Law.
And I'm Dana Duncan.
So, Dana, the last place that we left off, we were discussing the sequential process. Today, we're here to go through step 2 and step 3 of that process, but let's just first say that we're going to be dealing primarily with both severe impairments and severe impairments that might meet or equal a listing. So today we'll also kind of navigate out where your case might be both over 50 and under 50, and multiple factors that can go into those cases. What qualifies you for meeting a listing, maybe, what qualifies meeting a severe impairment, what these are, what they're not, and how to strengthen a potential claim. So briefly, let's just kind of re-walk over the legal framework. First, let's talk again, what is the sequential process, just as a review?
Well, the sequential process is a 5-step process that really has 6 steps. The first step is are you working? And as we talked about before, working has a very broad definition as to what it is you're doing. It's not just income, but it's got to be active income, something you produce. You can still work, but it does not reach a certain threshold, so that's not working. So that's a very broad term. The second step is do you have a severe impairment? Now, for a severe impairment, you have a medically determinable impairment or a severe impairment. They sound very similar, and they're very terms of art more than anything. Step 2 is it a medically determinable impairment? And it becomes a severe impairment when it limits your ability to work. Step 3 is you take the severe impairments and you evaluate them against a set of criteria, some numbers, some findings, some medical terms, and you determine whether you meet that medically determined condition. If you do, as a matter of law, that means it's an automatic, you become disabled, regardless of age or anything else. For example, if you are a quadriplegic, there are conditions or outlines in there that automatically qualify you for benefits. If you have ALS, you could qualify for benefits. If you have any other kind of conditions, pulmonary, vision, etc., there's rules about it. You automatically qualify. If you don't reach that level where you can automatically qualify, then they assess what your limitations are as the residual functional capacity. They then determine whether or not that residual functional capacity could prevent you from working in any of your past work. That's step 4. And if you can't do your past jobs, then they determine whether there are other jobs in significant numbers in the national economy that you can perform. If there are, you would not be disabled. If there are not, you are disabled.
So essentially, to boil down everything that we just went over, a sequential process is just essentially a legal equation by which there are certain variables that they are trying to measure. Step 1, we already went through previously in this show. Step 2, we'll be visiting today and a little bit into step 3. And we will have future episodes on steps 4 and 5. And each of those needs to be evaluated separately. If the answer is yes or no, then you move to a certain area. Either you're disabled or not disabled. And the eventual equation, if you have a good representative, should be, how do I get from point A, which is the start of a application, to a point of, are you disabled or not?
Correct. What you're really doing is like a big puzzle. Okay, you're trying to get all the pieces together to put the puzzle together. And that's the job of a good representative, is to look and find this evidence. The step 3 diagnosis or stuff is very complicated. And most people, most representatives don't really understand it, know how to apply it, know how to obtain the evidence to get it. It's the easiest way to get on disability, but also the hardest way to get on disability. And by that, I mean, if you can get the evidence together, you win. It's a matter of, though, getting the evidence together.
Okay, so we've already been through whether or not someone qualifies. That's step one. Today, we're here to focus on step two of this process and essentially what is or is not a severe impairment. So, you've been working in this industry for 30 plus years.
37.
There you go. Specifically on Social Security disability claims. Do you have kind of a rough working definition of what is or is not a severe impairment?
People have what are called medically determinable impairments all the time. They have, they have arthritis in the knee. They have depression. They have asthma. They have diabetes mellitus type 2, adult onset. Okay, if those conditions exist and they're diagnosed by a doctor, they're a medically determinable impairment.
So, if I could just stop you there for 1 second. So, essentially, having a diagnosis can lead you to a medically determinable impairment, but that by itself is not a severe impairment.
Correct. You have to go one step further. Does the severe impairment hinder or limit your ability to perform work? And that's the difference. We get people calling in and checking all the time, and they say, "Well, I have a severe impairment. I have depression." Well, and then you say, "Are you working?" Yes. Has it limited or affected your ability to work? No. I mean, I'm getting medication, I'm getting treatment. Okay, well, then I'm sorry, but that does not qualify you because you have to have something that shows that that impairment hinders or limits your ability to work. Now, in and of itself, one impairment does not necessarily qualify. It may be,
What do you mean qualify?
well, to as a severe impairment. You can have multiple severe impairments. Each has a certain limiting factor. The collective prevents you from working. So,
Okay, so you're saying not that it qualifies as a severe impairment, but rather qualifies you as potentially disabled.
correct. It's if it limits your ability to work in and of itself, that condition may not prevent you from working completely. But if you combine it with other factors, for example, if you have bad knees and you also have carpal tunnel, individually they may not prevent you from working, but it's going to be very difficult for you to do any kind of lifting and a light job if you have bad knees. And if you have carpal tunnel, you're not going to be using a computer very often, which is sedentary work. So the combination could mean you're disabled.
Now, I do want to make one small caveat here. Just because you have arthritis in your knees and carpal tunnel does not mean you will also be found disabled every single time. It depends
No,
on the severity of those conditions, what your treatment level is, and several other factors, which obviously is why we would always recommend that you have an experienced representative to help you through this process of how to develop a case so that
correct.
those two impairments might lead to something more that they could highlight and make sure that it's an emphasis to the decision makers at Social Security. But we just want to carve out that just because you may have those two conditions does not mean you will automatically get disability.
Correct. And I always teach any of the young reps that I have in my office that knowing when you have a strong enough case is not a term of law, it's a term of art. You get a feel for what will ultimately prevail. And so it becomes a gut feeling. I've got enough evidence or I don't have enough evidence. And whether a particular judge or ALJ will believe what you have to say. In our case, we're handling cases all over the country at this point in time, and we don't know all the judges, but I have resources available to find out stuff about judges, even if I've never been in front of them, and I have a good idea of what we need in order to win cases.
Now, the other element that I should mention here is that a medically determinable impairment, if it's in a short period of time, let's say, for example, you have an injury at work, you tear up your knee, you break your leg, you break your ankle, you injure your wrist, you do something that you will recover from before it reaches 12 months. That is also not a severe impairment.
Correct. It has to be a condition that is or that has limited your ability to work for 12 months or is likely to limit your ability to work for 12 months.
So it's something that's much more long-term or potentially permanent as opposed to something that you can recover from. So just because you had maybe an Achilles injury, so now you have to use a knee scooter around the office, does not mean that it is a severe impairment unless your recovery time is going to last for longer than those 12 months. But even then, when you recover, when your limitation for work-related activities ceases, then you will have probably what's called a closed period, and you will only have been disabled for that period of time. Now, that is also a potential for a successful case or claim, but that's going to be much more narrow than something that's a more permanent or long-standing condition that is likely not to ever completely recover from.
Correct. And you cannot combine them. So it can't be that you broke your leg and you were out for 8 months and then you ended up having a shoulder replacement that kept you out another 6 months. So you can't combine short-term injuries to get the year.
So, one of the things that we've mentioned to kind of define what is a severe impairment is a limitation to basic work activities. What are some basic work activities that Social Security uses to measure whether or not you actually have a severe impairment?
There are exertional and non-exertional limitations. And the definition is very simple. They have limitations that are exertional, and anything other than those is non-exertional.
Now, those are some very large words to the non initiated. Is there a more simple way of defining exertional versus non exertional?
Okay, so exertional means sitting, standing, lifting, carrying, pushing, and pulling.
So, you mean physical?
Not necessarily. As I indicated, exertional is just those. There are things that are physical that are called non-exertional. It's a strange thing Social Security does. There's all kinds of strange things that after 37 years I still don't understand. But there are a lot of non-exertional limitations that have exertion in them. For example, climbing ladders and stairs is considered not exertional. But if you've climbed up a ladder, it's exertional. It makes no sense. Stooping and bending. If you've got a bad back, stooping and bending is very exertional, but it's considered non exertional by Social Security. It's a strange system. But there are things that are non exertional that are in that category. For instance, the ability to talk to and handle public contact, being able to work at a regular work pace consistent with what the job requires. It also includes the ability to adapt to changes in the work environment.
Or to stress that may be happening in your daily activities,
Correct.
potentially taking instructions from supervisors or other coworkers, and
Yep.
understanding instructions of how to do your job.
Yep. And sometimes people have anxiety or PTSD or depression, and some days they struggle. And on those days, they could be absent or not productive, and that may qualify for disability. Those are non exertional, but there's a whole host. Vision is considered non exertional. Pulmonary problems, like if you can't be around dust, gases, fumes, for example, if you have asthma and it gets really bad, or if you have COPD and you've been a cleaner your whole life, you janitor, how are you going to use floor waxers or cleaners, toilet bowl cleaners, etc.? The fumes are going to cause or exacerbate your breathing problems. So those are the kinds of things that you look at. So basically, the thing to remember is exertional is sitting, standing, walking, carrying, lifting, and pushing and pulling. Everything else is considered non exertional if it limits your ability to perform some capacity of work.
And again, we should remind you here that just because you may have limitations in any one of these things, in your ability to walk, stand, lift, sit, understand instructions, take instructions from coworkers or supervisors, does not automatically qualify you for disability. You should consult a knowledgeable representative about the validity of your case before you try and move forward, particularly if you're trying to do this on your own.
Correct. For example, if you have a back injury and the doctor says you're not supposed to lift more than 40 pounds, that's not going to be a major limitation on your ability to work. It'll depend on age because age dictates what category qualifies you as far as exertional limitations, and you may not qualify. So, again, it's our responsibility as representatives to weed out where the problems are. And what our office does is if you call and you have limitations, etc., and we don't think your case is going to be able to obtain benefits, we will most of the time instruct you on what needs to be done. It could be that the doctor set this limitation and a further evaluation, or as time goes by, they could make that a more limited limitation or more limited return to work instruction, which may qualify you. But if you don't know that, you don't know to ask the doctor about it, you again have problems getting on disability.
Again, it is not your responsibility as someone who is a layperson to necessarily know what the variables are for this rather complicated equation that has been set up by the federal government and in many cases has been set up to work against claimants.
Yes, unfortunately. Every time they do something or representatives figure out a way to make it easier to get on disability, Social Security immediately changes the procedure or policy under the guise of we're trying to make this simpler. And what it really is making it tougher for people to qualify.
All right, so we've now established that whether or not you meet the qualification standards to apply for the program or the assistance that you're looking for, we've now established that you have to have a severe impairment. So that's steps 1 and steps 2. Now we progress further and we get to the kind of unknown ghost step of step 3. That for the most part is not something that happens in a lot of cases. It has to be evaluated in each and every case. But for the most part, most Social Security cases do not hinge on this step. So at step 3, we get to what are called listings. And this is the listings of impairments. Essentially, do you have a severe condition that meets certain criteria? And they have a category or basically a large dictionary book that has all of these various impairments, and they have subsections off of that. Again, this is why you should consult a representative who knows where to look for all of these things. And each of them has certain criteria. And if you check the box on 4 or 5 different things, then you automatically qualify for disability. But as the layperson, are you necessarily going to know what the 7 or 8 criteria are for meeting the listing for depression?
I'm going to let you in a little secret. There are a large number of representatives who have no idea how to use the listings. It's very complicated. Most of the time, you have to have medical substantiation. If you get the rare occasion where you can convince the administrative law judge to have a medical expert at your hearing, you have a very good chance of the medical expert saying the listing is met because there is not a proper evaluation of the listings that are done at the lower levels by the state agency doctors. Most of them do not have the time or resources to spend reviewing the cases against the listing to determine if they qualify. And I'm not sure they always have the most capability of determining it because some of the doctors at the state agency have no qualifications to opine on the conditions that the claimant has. You'll have an internist who has to discuss cardiac issues or diabetes issues. It just doesn't work as well.
So there are 2 sections to the listings. Basically, those who are under the age of 18, considered children, they have a specific category of listings that are more designed to capture limitations or severe disabilities that would be primarily found only in children or that they don't have to meet the adult criteria. And then there are the listings for anyone over 18. because for the most part, Social Security cases differentiate between when you are considered a legal adult and when you are considered a child. Now, as of that, there are certain categories that are included or lists of impairments: musculoskeletal, cardiovascular, respiratory, neurological, mental disorders, cancer. I know you mentioned ALS before. That falls in a certain category within the listings of impairments. And each of these has specific criteria that you have to meet. Again, consult a seasoned representative to help you go through and navigate what you may or not be eligible for or capable of either what's called meeting, which is as you meet all of the criteria, or in some cases, it's equaling. And what is equaling, Dad?
Equaling, again, is a term of art. It's where you have multiple medical conditions that, when combined, would mean that the listing is met prohibiting work. It also can mean that the listing is not necessarily directly the medical condition. Social Security, instead of coming up with an actual listing for migraine headaches, says, no, use the epilepsy listing. And so you have to apply the factors in the epilepsy listing against the criteria of how many migraines and such and deal with it that way. And that's an equaling. I don't know why they don't create a migraine listing, but as I've said many times, I've given up trying to understand the Social Security Administration because either I would go crazy or if I somehow figured it out, I could have retired by now.
And it is an important note yet again, simply a diagnosis alone is not enough to say whether or not you have the specific medical findings to meet or equal a listing. You need a
Yes.
legal representative to navigate through all of the medical information to make a case, an argument to a decision maker at Social Security, whether that be the state agency or the administrative law judge at a potential hearing, in order to be found disabled.
Correct.
So let's quickly go through. Now, we've basically established steps 1 through 3. What are some common misconceptions that we haven't discussed already?
If I have a diagnosis, I must qualify. Okay. That doesn't matter. The diagnosis alone is not enough. As I've indicated in the opening, millions of people in the United States have depression, but a large portion of those are functioning, properly treated, on medication, and don't have any major problems working. That in alone is not enough. Another popular misconception is that multiple minor medical impairments do not count towards disability. If you have multiple problems that are relatively in and of themselves minor, they can combine to prevent you from working. For example, you may have a back impairment that prevents you from doing what's called production work. In other words, fast paced, where it's an assembly line or something that has requirements of production. But at the same time, you may have relatively minor depression or anxiety that prevents you from being able to talk to people you don't know very well. You combine those together and you're 50 years old and limited to, it's sedentary type work. Jobs in the sedentary field either are assembly work, where you're small parts assembly, or they're customer service jobs. So if you have minor limitations in both that prevent you from doing those two facets, it may be enough by itself to qualify you for disability.
Simply put, if you have one major condition, but it doesn't meet a listing, you may have some other minor conditions that will help towards a finding of disability, even if you don't meet it at step 3. Because as we have yet to go through, steps 4 and 5 have multiple other variables that you have to navigate through, and any and all medical information about you can be relevant to your case.
Correct. In fact, when you're assessing the overall impact, and that would be what is turned into your total limitations, it's called the residual functional capacity. And when assessing that, the judge has to take into account, the administrative law judge at hearing, has to take into account both the severe impairments that are clearly disabling or have work function, as well as any non-severe impairments. It may be that your depression is not in and of itself disabling, but it could be enough that it reduces your ability to do certain things. It may be enough then for you to be found disabled, even if it's a non-severe impairment. It could ultimately impact the outcome.
Now, another one I just want to briefly discuss, and we'll kind of use it as a transition into our next topic, but mental impairments are harder to prove. That's somewhat true. The American medical system, Social Security, the government are not set up to handle mental health conditions rather well. We are going through a national evolution on how to treat and properly assess as a society mental health. And we have not yet gotten to the place where we've come to accepted standards on what is or isn't severe issues of mental health. I think for the most part, we've started to come around to what is the most severe situations, but it's not always something you can easily see, unlike a broken ankle. So, in this particular situation, just because you have more difficulty trying to prove a mental disability or severe impairment does not mean that it won't be important to your case, as Dana has already laid out. The importance here is going to be make sure you are treating with a licensed professional and that there is medical documentation of just about everything having to do with your condition. Even a minor issue can make a big deal in your overall case.
When you're dealing with disability, unfortunately, documentation is the key. So if you're having a mental limitation or a mental condition only, it's important for you to be in treatment. You may not feel that your therapist is helping you, but at the very least, having the therapist's notes as to what you're discussing and the fact that you're having continued problems helps your claim for disability.
Now, we have highlighted several instances where it's very helpful to have a legal representative. We are obviously biased as we are legal representatives ourselves, handling these
Yes.
cases on a regular basis. But there are a couple of other ways in which representatives can clearly help you through steps 2 and 3. One is knowing how to describe limitations and impairments very clearly in applications in language that will be in Social Security's terms. That will help you with navigating a easier process. Another one is knowing when to seek legal help versus also knowing when to appeal a case. All of those are things that you should seek advisement for before you try and continue this on your own. As Dana has often said, and I know he said in our initial episode, there are certain other things that you would never imagine doing by yourself, such as taking out your appendix or doing a root canal. This is probably one of those processes that you could try and do by yourself, but it's certainly easier if you have somebody who knows what they're doing.
True. That's exactly the point. Is there's things that you may say or do that you don't think have any impact at all that could sabotage your case.
So let's just do a quick recap here. We've discussed both steps 2 and 3 here today. We worked on a very basic raw definition of what is a severe impairment, essentially an impairment or combination of impairments that significantly limits one's ability to perform basic work activities such as walking, standing, understanding instructions, things of that nature. And we talked briefly about what listings are, which is a series of severe medical conditions that, if they meet certain criteria, are automatically disabling for a Social Security claim. Now, we would, of course, yet again, encourage you to consult legal professionals if you're unsure of how to navigate all of the equation of the sequential process. We, as a disability firm, are available to help people with any questions on this going forward. If you are in the Midwest or specifically in the Wisconsin region, we can be reached at duncandisability.com, or you can find us on any of our socials at either Seeking Disability or at Duncan Disability. So, next episode, we will talk about how to build a stronger disability case by going over what's called the residual functional capacity and step 4 of this process. Of course, there's a lot more information to share, but that's a good place to stop for this episode. If you have more questions about disability, you can visit our website, duncandisability.com, or call 1-888-458-2406 to talk to the Duncan Disability staff. Thank you for listening. We'll see you next time. Seeking Disability is a production of Ronnie Duncan Studios. This show is written by Dana and Thomas Duncan. It is mixed, edited, and recorded by Thomas Duncan. Our music is thanks to Purple Planet Music. Our technical provider is Riverside FM, and our distributor is Captivate FM.